all of you had a good break over Christmas and New Year and are ready to resume our discussions on the proposed wind farm at Cairn, Duhie. Can I first ask that everybody turns on their video but mute their microphones just for the introductory phase of proceedings? I noted just before we started, Mr. Trinick, that you appeared to have a microphone issue. Hopefully that is resolved. If you can see and hear me, Miss Haywood and I are both in a conference room at the DPEA offices in Falkirk. So if you can both clearly see if you can clearly see and hear both of us, could you please put your thumbs up? Thank you. I'll carry on. Welcome everybody to the hearing session into policy matters relating to the application by Renewable Energy Systems Limited for consent for the construction and operation of a 16 turbine wind farm and associated infrastructure, which is proposed to be sited approximately 15 kilometres southeast of Nairn and within the Highland Council area. I will refer to it as Cairn Duhie Wind Farm during these proceedings. My name is Sinead Lynch and I am a reporter with the Scottish Government's Planning and Environmental Appeals Division. I've been appointed jointly with Ms. Karen Haywood, who is an Assistant Chief Reporter, to hold the inquiry and hearings and prepare the report to Scottish ministers on this application submitted under Section 36 of the 1989 Electricity Act. In Section 36 cases, it is the ministers who will ultimately decide whether or not to approve the application after consideration of our report. In terms of the process, to date, we have already held an inquiry session and a hearing session into conditions. Those were held earlier in December. The main purpose of today's session is to ensure that we fully understand the positions of parties on relevant policy matters and in particular National Planning Framework 4. Where there is a dispute on in terms of the positions of the parties, we need to be clear on the reasons for that dispute. When we are content that we fully understand the position on a particular matter or a particular issue, there won't be any questions from us today, as we already have the benefit of substantial written submissions from each party. Could I ask the participants in each team to introduce themselves, starting with the applicant?
Thank you, ma'am. Thank you, ma'am. Thank you, ma'am. Thank you, ma'am. Thank you, ma'am.
No problem.
Can you hear me now? Echo. I do apologise for this technical difficulty.
No, that's fine. It happens. Would you like a moment to resolve it? Or do you perhaps need to leave and rejoin the meeting, see if that resolves it?
There's still an echo at this end. I do apologise. I think you could. Would you give us 5 minutes to try and resolve this?
Absolutely. Absolutely. Is it?
I would just say that, Mr. Trinick, at the end there was no echo at our end when you were last speaking, just immediately.
Let's try it again.
I can hear you in the background. Too much of a good thing.
Right, if we could all take 5 minutes and then hopefully it will be resolved.
No, she's adjourned it now anyway.
We need them on so we can hear if they can test if they can hear us.
1, 2, 3, 4, 5. No, still.
To introduce themselves, beginning with the applicant. So if we could continue from there.
Thank you, ma'am. My name is Marcus Trinnick. I'm a solicitor, King's Counsel, instructed by Fraser Gillis, partner at Wright Johnson Mackenzie. Sitting with me to my left, or you won't see to the left, but he's sitting here anyway, is David Bell, who will give most of the evidence today. Also in the room, Fraser Gillis, Ray Smith from Renewable Energy Systems, and Lizzie Pinch from Wright Johnson Mackenzie. Thank you very much.
Lovely. Thank you very much, Mr. Trinnick. And then to the council, Mr. Findlay, if you could introduce your team.
Yes, good morning, ma'am. My name's James Findlay, King's Counsel, Scotland and England and Wales. I have one member of the team, Simon Heinson, with me this morning. We'll be sharing the duties.
Lovely. Thank you very much. I can see from the list of participants, we don't appear to have any third-party observers. There may obviously be people watching on the webcast, but I'm not anticipating any other participants today. Thank you both for the introductions to your respective teams. I would remind you that Ms. Haywood and I carried out unaccompanied site visits of the site and the locality in October 2002. We viewed the site from the viewpoint set out in the environmental reports and from the routes surrounding the site, including the A939, the A940, the B9007, the road to the south of Loch and Dorb, which connects the two latter routes mentioned. And we also walked part of the Dava Way, including the relevant viewpoints in the vicinity of the Dava Way. And we also viewed the general vicinity of the site. Following the conclusion of the inquiry session in December, we decided that additional site visits were not required. I would remind you that this hearing will be webcast live at dpea.public.i.tv. The video recording of this session will be retained on the DPEA public.i.tv website after the appeal is determined. And by taking part in this session, you are consenting to being filmed and also consenting to the use and storage of those images and sound recordings and any information contained within them for webcasting and training purposes and for the purposes of historical records and making those records available to the public. We are sorry that this session is not being held in person, but expediency has meant that a virtual session is more efficient. We are confident it will run smoothly, subject to any tech issues and Wi-Fi. We have advised you of the likely timetable for this session, and you have been provided with a hearing agenda. We are confident that all the matters on that agenda will be addressed today. For the benefit of those watching, I will very briefly explain the process that will be followed through this virtual hearing. Obviously, we began at 10 a.m. this morning. We will run to lunch hour, where I anticipate we will take an hour's break. It can be very intense, focusing on the screens all day and following what is being said. So we will try and take regular screen breaks, probably every hour or so, where there's a natural break in the proceedings. If anybody, for any reason, feels they need to pause to catch up with the discussion, please let me know. As you all have the relevant documents, it is not planned to show the documents on the webcast. You're expected to work from your own electronic devices to access any relevant information. All the documents have been published on the DPA website under the case reference WIN-270-16. You may use smartphones or any other communication devices you wish during the hearing session. This is entirely acceptable, but should not be audible to any other party. And you're also reminded that discussions amongst team members should take place off camera and should not be audible. All teams must adhere to current government guidance on COVID-19 when participating. Should any participant be taken ill, we will adjourn to ensure medical attention is sought. And should such an occurrence happen, I will consult parties as how to and when to reconvene. We do have members of the DPA IT staff on hand throughout the proceedings today. Both Lucy Wakeham and Callum Henderson will be on hand and will try and address any technical issues should they arise. We have one hearing session planned to take place today, only on policy, and we will aim to finish by at least 5 p.m, if not before. Are parties happy with those suggested timings?
Yeah, just have one issue in that Mr. Heinsohn is not going to be able to be present, I think, from about 3:30 to 4:30.
So 3 till 3:30.
3 to 3:30. For reasons I can go into if necessary, but with luck, we may not still be going then. But if we are, it may need to have an extended break built into the programme at that stage.
Well, let's see where we get to as we come to about 2:30. And as you say, if luck is on our side, it shouldn't be a problem. But I have noted it.
Thank you very much.
Okay. For those watching who are not familiar with the hearing process, the normal sequence of events for the day is as follows. Reporters ask any questions they may have on the topics as set out on the agenda. The parties then respond in the order of the applicant and then the council. We as reporters may have follow-up questions arising from that discussion, and we will direct those to the relevant party. There may be relevant questions from the floor, but they will always be directed through the reporters in the first instance. When we are satisfied that we have sufficient information, we will indicate that to you and move on to the next agenda item. When the discussion on all topics is concluded, parties will have the opportunity to make a closing submission in writing, although this is not obligatory. We have discussed this previously at the end of the inquiry session, and it was agreed that the council would make a closing submission by the 10th of February 2023 and the applicant by the 24th of February 2023. In addition to the evidence that we will hear, our report will also consider a range of other matters which had been raised in consultation responses and the written representation submitted with this appeal. The details of all of those can be viewed on the DPEA website. Before we finish with some minor housekeeping issues, we would remind everybody of the importance of being courteous today. Please remember to be polite and respect other parties' rights to have enough time to understand the questions or the responses or to explain their position. So moving to some minor housekeeping matters. The use of the microphone is obviously very important during virtual events, both to record the sound and to enable people to understand the proceedings. When you're not speaking, please try to remember to mute your microphone, and that will hopefully avoid any unnecessary interruptions. You're still able to intervene by attracting the attention of the reporters. And if you need to do this, please switch your video back on and raise your hand. To do that, it is important that you raise any matters through the reporters in the first instance. And we should all try and be patient, because in the course of today, it is very likely that we will all forget at some point to mute or unmute our microphones. If this happens, please just signal and give the person who's muted or unmuted the opportunity to address the problem. We have no fire alarm test in our offices today, so hopefully will not be disturbed, and I'm assuming the same is right for all of you wherever you are. At the end of this introduction, I would ask that participants not involved in giving evidence or responding to a question to switch off their video and mute their microphones. I have noted from the attendance list that, as I mentioned earlier, we don't appear to have any third or external parties in the actual hearing today. So leaving your video on should not be a problem, but please bear in mind my comments about muting and unmuting microphones. Before we move to the start of the hearing session itself, are there any questions on the procedural matters I have mentioned? No? Thank you. Are there any other preliminary matters that anybody wishes to raise at this point before we move into consideration of item 2 on the agenda? No? Excellent. Thank you all very much. Well, moving to the agenda, let's begin at National Renewable Energy Policy. The discussion points I have listed relate primarily to National Planning Framework 4 and the implications of that for this proposal. I'd like to focus on the key provisions of National Planning Framework 4 and the similarities and differences with outgoing national policy, being National Planning Framework 3 and Scottish Planning Policy, insofar as those are relevant to the assessment of the proposal for a wind farm at Cairn Duhie. Today, we will look at the spatial principle as set out in NPF4, the idea of a just transition and the implications of that, national development categorisation, policy 1 of NPF4, policy 11 of NPF4, and any other relevant policies and their requirements and implications for this proposal. If we turn to NPF4 Part 1, we could begin with the spatial strategy and the spatial principles, which effectively set the scene and the basis for the policy approach which follows in NPF4. I'd like to explore what is considered to be the overarching thrust of NPF4. As part of this, I'd like to explore what the spatial principles of a just transition actually might mean in practice. Could I ask Mr. Bell to begin the discussion, perhaps focusing as much as you can about what you think is new and noteworthy in terms of the spatial strategy as set out in Part 1 of NPF4.
Thank you, Mum. Good morning. Just one question for me. That's quite different from the agenda point, the first item on the agenda. In terms of the emphasis for onshore wind energy, are you happy for me to bring in the first agenda item as well, in addition to your specific question?
Yes,
or are you coming back?
Well, I will be coming back, but really what I did want to focus, that first agenda point is, does the document represent a change in emphasis for onshore wind energy, and are there implications for the delivery of that proposal? It's essentially, as far as I'm concerned, the same point. What is new and noteworthy about NPF4 in terms of onshore wind energy?
That's fine, and I'll bring in the just transition that you've mentioned.
Yes,
I
please
think
do.
the simple answer to that first agenda point would be yes, there is a change in emphasis on onshore wind, and yes, there are implications for delivery in terms of consent handling and the weight to be given to benefit. That's the sort of straightforward, high-level response. In NPF4, there are a few points to highlight to expand on that, and I think it's also helpful to read across to the onshore wind policy statement, because both generally published at the same time, and there are some specific references within the OWPS to NPF4. So there is the intention that there's a joined up policy approach between the two. But to start with the spatial principles, the just transition is the first one, and probably the one of most relevance to the development. And it may be we look at more detail on that in terms of the just transition plan draft that's been issued. But there's also specific guidance within the onshore wind policy statement of what the just transition means in terms of onshore wind energy. But the big point in the just transition is the statement from the government that they want the fastest possible move away from oil and gas to renewable energy. And it's a very bold statement, and that's in the draft energy strategy. And within the spatial principles, in page 4 of NPF, there are 3 elements of the spatial strategy: sustainable places, livable places, and productive places. This project slots within the sustainable places theme, and the national development that would be engaged in terms of National Development 3 is relevant in that regard. Again, still looking at page 4 of the NPF, second last paragraph, it states national developments will be a focus for delivery. That's for the spatial strategy. So I think there's a fitting together of these elements. You've got the spatial principles, of which the just transition is a particularly important one. We then apply these through sustainable places to try and achieve a sustainable place. And the government saying to get a sustainable place, we want the delivery of a certain number of national developments, of which this project would be one. And I won't go into what national development means, because I think that's further down your agenda. But we know that there's a statement. We know there's a statement of need as well, and we'll maybe come to that later. What I would say in terms of the emphasis for onshore wind, which is your first item in the agenda, in the onshore wind policy statement, we get for the very first time in Scotland a specific target for onshore wind of 20 gigawatts by 2030. And as I said in my hearing statement, that's about 130% increase of the current installed capacity to be built and operational in about 7 years. And within the onshore wind statement, I'll just give a couple of references because I know this is coming up later, but to take it briefly, 1.1.2, it states we must go further and faster than before. 1.1.3, this will require a substantial increase in installed capacity across all technologies. But then it goes on page 6 to state a minimum installed capacity of 20 gigawatts of onshore wind by 2030. And then at the very end of the document, in the conclusions, there is on page 49, it states deployment of onshore wind is mission critical for meeting our climate targets. So I would say that terms of the first item, there is a change of emphasis in onshore wind, and there are implications for the delivery of the proposal in terms of how a decision maker would interpret and apply the specific policies within NPF4 read across to the OWPS. Thank you.
Thank you, Mr. Bell. Ms. Haywood, do you have any questions? I just had one follow-up question on that, Mr. Bell. Do you think taking the suite of energy-related strategy and policy that has been emerging, do you think that NPF4 enables decision makers to make those decisions to deliver the onshore wind policy and the energy strategy as envisaged by Scottish Government?
Yes, I do. Yes. And we'll perhaps illuminate how that happens once we start going through the policies to see what that means for development management.
Okay, thank you, Mr. Bell. Mr. Heinsohn, could we move to you and looking again for your views on the same matter? Thank you.
Yeah, thank you. Good morning. I don't think there's that much between the parties on this matter. There has been a change in emphasis in National Planning Framework 4 and obviously the onshore wind energy policy statement. However, what that change in emphasis has done is effectively put in policy wording the way in which decisions were already being made by Scottish ministers and by reporters, and to a point, the planning authority, where greater weight had been put on the climate emergency and on renewable energy targets in recent years. But there is in Scottish planning policy set out, as did NPF4 and the former onshore wind energy policy statement, it did set out there was that need for onshore wind energy development to meet the targets. There is that, as Mr. Bell set out, there is that phrase setting out it's mission critical. And in terms of the just transition, the fastest possible move away from oil and gas, the onshore wind energy will provide that in the short term, but it's not the only technology available. And obviously, there's more offshore wind coming online as well over the course of the next few years, albeit the ScotWind projects are likely to be much later, and they're the ones where we'll get a greater delivery from. In terms of the made a few notes when when Mr. Bell was talking. Yeah, they joined a policy approach between National Planning Framework for the onshore wind energy policy statement and the draft energy strategy and just transition plan. I think the other one that is important and there's cross links to is the Scotland's third land use strategy, which is cross-referenced to in the onshore wind energy statement, and that still sets out that a balance is required. Where there is that emphasis on delivery of onshore wind, a balance is still required between the benefits and disbenefits of the scheme, which would be a planning judgment to be taken forward.
Okay.
Perhaps I can add two things in support of what Mr. Heinsohn's just said by reference to Mr. Bell's statement. Firstly, just ask you to note that paragraphs 2.88 to 2.8.13, Mr. Bell has extracted some comments from the reporter's decision in Rothes 3, which bears out a lot of what Mr. Heinsohn is just saying, that the extent to which weight was being given to the climate crisis and so forth and so on. I just draw that to your attention, but add a caveat at this stage, which will appear in closing submissions, that perhaps the Scottish ministers didn't go so far as the reporters, but one can That's a matter for detailed discussion, but it's an indication of how high the case could have been put before NPF4. That's the first point. And the second point is, if Mr. Bell helpfully deals with the differences with SPP, paragraph 4.149 of his report, it may just be worth looking at the 5, I'll call them bullet points, but they might be bullet arrows or arrowheads that he's used there. So the first one is explicit, picks up entirely what Mr. Heinsohn was referring to, the explicit instruction to apply significant weight to the renewable energy generation and greenhouse gas emission reduction targets. Well, our case, as Mr. Heinsohn's made clear, both in orally and in writing, is that has been the case and the approach that reporters have taken, and indeed Highland Council has taken. So that bears out entirely his point. There's been a change of emphasis, but in terms of the policy of guidance, that's new, giving a specific instruction. But whether that change of emphasis will result in a different process is another matter. The second matter relates to national parks and national scenic areas. But outside of that is one of general support. That's noted as a fundamental shift away from the spatial framework approach, and indeed there is a fundamental shift from the spatial framework approach. But again, the reality is that this site, as with many others, were treated in Group 3, where there was, if you like, in principle support in any event. The reference then to landscape and visual impacts, which are to be expected, and localised landscape and visual impacts. Again, that's a matter Mr. Heinsohn dealt with in his statement. Those are considerations which reporters were taking into account in any event, in particular that localised landscape and visual impacts may not justify a refusal. The fourth point is renewed emphasis on economic benefits and maximising of economic impact. I don't think I need to say any more about that for the purposes of this discussion. And the omission of reference to tourism, being Mr. Bell's fifth identified point, is again a notable change in emphasis, but it forms no part of this case, and hasn't, if it ever did, hasn't for a very long time formed part of any Highland Council justification for refusing a wind farm. So I just do that to add a little bit of meat to Mr. Heinsohn's bone in terms of there is a change of emphasis, but the impact of that is where perhaps the parties do disagree.
Okay. Thank you, Mr. Finlay. Mr. Trinick?
Thank you, ma'am. Yes, just coming back on something that, well, both Mr. Heinsohn and Mr. Finlay have said, and Mr. Bell will come in after me. I think they anticipated that what has been said will be said. And what I mean is that Highland Council were taking the approach of NPF4 before NPF4 anyway. We can disagree or agree about that. I need some case examples before I agreed it, and they're not before you. I think we disagree on balance on our experience of Section 36 projects and Planning Act projects in Highland. However, I don't think that's material. The comparison here is not between NPF4 and what Highland Council may have done in the past. We're talking here about the application of policy as between NPF4 and SPP. It's what difference NPF4 makes to the application of policy in policy terms. I'd also note that NPF4 is addressed to reporters as well. It's not simply addressed to Highland Council. Some reporters undoubtedly anticipated pretty well what might come out of NPF4, for example, the Clashgar and Rothes decisions, which are before the inquiry. But some, without naming names, some we take the view did not anticipate it so well. Indeed, I might note that Mr. Seaton, in paragraph 2.180 and 2.181 of his Rothes 3 report, which is actually quoted by Mr. Bell at hearing statement paragraph 2.813, actually noted that he had changed his position on this precise point after the Galty-Clay report. You can see the emergence of Mr. Seaton's thinking But NPF4 is addressed to reporters and not simply to Highland Council. The ministers have clearly said that NPF4 represents a rebalancing of the planning system. It's a step change. If you look at Mr. Arthur's closing remarks in Parliament on January whenever it was, and those are noted by Mr. Bell in his hearing statement as a footnote to his paragraph 414. NPF4 is a step change. It introduces for the first time the concepts of the twin crises of climate change and the nature crisis. So if planning authorities are to take the view it's more of an evolution of what was going on anyway, we were doing what NPF4 said before NPF4 came out, A, I disagree, and B, I think they're missing the point, which is the step change. I'll hand over to Mr. Bell to finish off the point.
Yes, thank you. I'll take it fairly briefly, but it was just, I think Mr. Vincent was saying it's the way in which decisions are already being made and significant weight was applied to benefits. I think what we'll come on to see is that there's significant weight to be applied in relation to policy 1 of NPF4. And there's also significant weight in terms of the specific contribution to targets in policy 11. I think a very important point is that we actually get some more guidance on landscape and visual matter and the matter of weight in the onshore wind policy statement. And it's section 3.6 on page 19 of the onshore wind policy statement, specifically refers to NPF4. Now, Mr. Finlay took you to the section of my hearing statement where I deal with differences of policy 11 with the outgoing SPP, not the broader picture in terms of differences of the wider NPF4. We'll come on to that on the agenda in terms of national development. But if you look at paragraph 3.6.1 in the onshore wind statement, and I think this is an important read across from NPF4. So it talks about meeting the ambition of the 20 gigawatts will require taller and more efficient turbines. This will change the landscape underlined. But then it goes on to talk about LDPs realising their full potential. That's fine. And then it says this, outside of the only areas where wind energy is not supported are national parks and national scenic areas. Outside of these areas, the criteria for assessing proposals have been updated. We can see that in policy 11. And then it says, including a stronger weight to be afforded to the contribution of the development to the climate emergency as well as community benefits. So I think the word stronger is important there. That means whatever Highland Council or we were giving to the benefits in December or before, it has to be something extra now, by the very definition of the word stronger. So put another way, that would mean there has to be an acceptance of a greater degree of harm than would otherwise have come about under the previous policy. It's inevitable. If you're giving stronger weight to the benefits, it must mean you're giving lesser weight to something else. And in that regard, we'll come on to see how the government has given us greater specific policy guidance on things like wildland areas, peatlands, local landscape areas, where it is putting that into development management operationalisation, if you like. But I wanted to make that point about the stronger weight, because I think that is a fundamental change and direction to decision makers that is clearly different to what we had before. Thank you.
Thank you, Mr. Bell. Going back to the council and focusing specifically on that point of appreciating the matters that are taken into account when previously assessing Section 36 cases in Highland Council, could the council accept that the emphasis has changed and therefore the weight assigned to the various characteristics that need to be assessed has changed? The balance still has to be achieved, but the scales might be tipped more in one direction than they had been previously, even if these are things that, as a matter of course, you took into account when making assessments. Has NPF4 changed that emphasis?
It has, in terms of the policy wording, absolutely. There was I suppose, the tilted balance before in favour of proposals that contribute towards sustainable development. That's echoed in the policy test that was in the Highland-wide local development plan as well. That wind energy proposals would be supported, or renewable energy proposals would be supported, unless they're significantly detrimental overall. So again, there was that positive attitude towards renewable energy developments. I think, yes, there is the change in emphasis in terms of the policy wording to set out that there is stronger weight being afforded to the contribution. But as I mentioned before, the way in which the policies were implemented in the latter days of SPP and NPF4, sorry, and NPF3, then stronger weight was being applied. But in terms of what Mr. Bell was saying, I don't necessarily disagree with what he said in terms of that stronger weight being applied, but it's not necessarily the stronger weight being applied between decisions that were made in December and now. It's the stronger weight being applied in policy terms rather than necessarily in terms of the written policy. So it's that change in emphasis in the written policy, not necessarily the change in emphasis in the way in which decisions were made, but that balance still needs to be struck.
Okay, thank you, Mr. Heinsohn. I'm content that I have probably heard sufficient from the parties. Ms. Haywood, do you have any further questions? No. Right. If we could move to just transition, and an exploratory question I have relating to that first agenda point and the matter of a just transition. Can it be assumed that a just transition would be achieved if developments which are approved are in accordance with the policies as set out in NPF4? Is that spatial principle of a just transition something that we need to consider in individual cases, or is it simply a matter that is more strategic in terms of NPF4's aims? Mr. Heinsohn, you outlined in paragraph 2.2 of your hearing statement that a just transition is one of the spatial principles of NPF4, but I didn't glean from your hearing statement whether or not the Council considers that the applicant has aligned with this principle in terms of the Cairn Duhie proposal in particular. Could you say a little bit more about that at this point?
So I think in the lead up to the question you just put there in terms of the just transition, I think we see it as a overarching matter that is relevant rather than necessarily one that would require to be considered in a detailed manner for each application in terms of the way in which the proposal would contribute towards a just transition, or whether or not the proposal would lead to a just transition. I don't think it would be possible for any individual project to lead to a just transition by itself as part of that kind of wider emphasis through the fact that schemes over 50 megawatts are national or considered national developments. It's the contribution of onshore wind energy developments and other strategic renewable developments to that just transition as a collective in a way, albeit every little bit plays its part. It's rather as a collective and that overarching principle.
Thank you. And do you think that a just transition in general terms and sort of at a strategic level could be achieved when developments align with the policies as set out in NPF4?
I think it could be, yes.
Thank you, Mr. Heinsohn. Mr. Finlay?
Perhaps I could just add something to that. The concept of just transition, I agree entirely, obviously, with what Mr. Heinsohn's just said. But the idea of just transition is, I think, referred to in Mr. Heinsohn's statement because it bears upon whether the idea of planning balance and balancing a number of factors, and those factors are a way of taking forward the idea of just transition. So it is an overriding spatial part of the strategy as such, but it doesn't need to be addressed in each particular case, but one can see how it then follows through into the particular policies in NPF4, and indeed would be something to bear in mind when approaching both NPF4 and other parts of the development plan when they have to be read together.
Thank you, Mr. Finlay. Mr. Bell and Mr. Trinick, do you have any comments on that question I had for the council?
Yes, thank you. I don't disagree with what Mr. Heinsohn said. I think he put it very well in terms of that collective approach to achieving the just transition. I think there's two documents that help in understanding that, one more than the other. Firstly, in terms of the draft energy strategy and just transition plan, by its very title, it clearly is relevant to that. And what I said at the start about the fastest possible move away from oil and gas, that's page 2 of the draft strategy. There's clearly a big implication for the northeast of Scotland and jobs, reskilling, employment potential and so on, that will be concerning to communities, and that will have potentially land use implications. And page 9 of the strategy talks about hydrogen as an emerging sector, and the government says it's perfectly placed to support a just transition for existing oil and gas workforces. You can see how the government's thinking that if people are made unemployed from oil and gas companies, then they could move into new gas companies by way of hydrogen deployment. So the question would be, well, how does that relate to onshore wind? In the onshore wind policy statement, I think there's about 30 references to the just transition. But I could give you, for your note, 6 references that I think are particularly helpful. I'll be fairly brief, but 2.1.1 states that the government is committed to achieving climate change targets in a way that maximises the economic and social benefits of a just transition to net zero. And then 2.2.2.1, just below that, this refers to the strategic leadership group and the sector deal that's to be set up for onshore wind, and will identify solutions to key deployment challenges and foster a collaborative spirit across the sector whilst aiding a just transition. And then 2.4.7, it is crucial that the principles of a just transition are actively applied across the sector, and that the benefits of the increased deployment of onshore wind are felt by all of Scotland's citizens, especially in the communities that host developments. And 3.3.3, about the investment in peatland restoration and green jobs. This will be play an important part in Scotland's just transition to net zero in terms of the rural area. And then perhaps most importantly, at 5.5.9, it says our just transition plan makes clear the Scottish Government's commitment to developing our economy in a way that brings Scotland's citizens with us. And we believe that onshore wind will play a significant role in that journey. So when you look at other aspects of the onshore statement in terms of the level of investment that's expected in the sector in Scotland's rural areas, and the level of deployment, which could potentially lead to remanufacturing, and the government states that in terms of supply chain. So I think I would read into that the aspiration is that if Scotland deploys at the scale that is envisaged with the target, then that could be a stimulus to the supply chain. And that will be something that the sector deal will be looking at. And that may move into things like towers being again manufactured in Scotland. And so therefore, the main linkage of the Just Transition Plan, as I would see it, is in the socioeconomic benefits. It's not so much the balance of factors, it's what can projects deliver in terms of local and regional economies, and collectively, as Mr. Hinson put it, in terms of that stimulus to the supply chain. Thank you.
Okay, thank you, Mr. Bell. Any final comments from anybody before we move on from that point? No, thank you. I had in the agenda the Chief Planner's letter of January 2023. If we could leave that point, and I'll come on to it at the very end of our discussion on NPF4, if we could move to NPF4 Part 1. And I had looked at the National Spatial Strategy, which we've already discussed, the alignment of the proposed development with the relevant principles. I think we've broadly discussed the spatial strategy and the relevant principles. Would the parties be happy to move to national developments in relation to this particular proposal? Okay. I noted that NPF4 at page 103 of the document relates to renewable energy generation as National Development 3, with other references earlier in the document and an overview provided at page 97. Mr. Bell, your hearing statement at paragraph 4.1.34 sets out that the proposed development at Cairn Duhie is of national importance for the delivery of the National Spatial Strategy. And Mr. Heinsohn, your hearing statement at paragraph 2.6 says that national developments remain to be assessed against the provisions of the development plan, of which NPF4 is part. Starting with Mr. Bell, what do you consider are the practical implications of a proposal being classed as a national development, or indeed, are there any? And in applying a balance to the assessment of such a proposal, does such a classification, i.e. as a national development, affect the weight given to other considerations? And I have a third strand to my question. Does such a classification as a national development in NPF4 affect the application of other policies as set out in the development plan, including NPF4? Now, I realise that's a fairly lengthy question, but Mr. Bell, if I could ask you to start.
Thank you. I think firstly, in terms of the national development approach, it's not new. We've had it in NPF3, and we're experienced at dealing with that. And the first point to make is that they've been the top of the hierarchy in terms of developments in Scotland. That reflects their strategic importance. And to date, they've been for, I suppose, quite special developments that are important for the overall national land use strategy, such as container ports and so on. And for the very first time, we've had individual renewable generating developments elevated to that status. That of itself is an important material factor that has to carry through, in my view, into the planning balance that is eventually struck. We know that the government stated, page 97 of NPF4, that these are significant developments of national importance to deliver the spatial strategy. We also have the statement of need on page 103, which states, and I'll just quote the first part, additional electricity generation from renewables and electricity transmission capacity of scale is fundamental to achieving a net zero economy. we also see at the top of page 103 a large and rapid increase in electricity generation from renewable sources will be essential for Scotland to meet its net zero emissions targets. And therefore, when we look at applying this consideration in terms of your second question in the balance, we know in policy 11 that in considering the impacts that arise from a development, significant weight is to be placed on the contribution of the proposal to renewable energy generation targets. So remembering that point about scale and importance and strategic significance, then in my view, that has to have a bearing on the weight to be given in balancing the impacts. And in terms of the third point you raised, in terms of how that might affect other policies. If we take, for example, one matter that is particularly pertinent to this case, which is policy 4 in terms of natural places. There is, we'll come on to it in the agenda, a balancing mechanism that requires consideration of the benefits in a given case. We know for national developments in paragraph 4C that that relates to benefits of national importance, and in terms of effects upon a development that is affecting a local landscape area, then the threshold is local importance. So there's a clear application of the national development status, which would deliver national benefits in that particular policy in terms of how it is applied. There may be other aspects of policy where that would come in as well, and I think policy 1 is an important one, where significant weight is to be given as well to proposals in terms of the global climate and nature crisis. And this
Sorry, Mr. Bell, sorry to interrupt there. Just going back to the point you made there about policy 4C, doesn't policy 4C just apply to national park, national scenic area, the sites that they've outlined there? So doesn't policy 4C2 only apply in those areas? It's not
yes,
talking
it
about
does. I was just giving the example of if you were dealing with a national development, there's a reference to benefits being of national importance. So I'm not saying that 4C applies, it's 4D clearly in this case.
Thank you.
Yeah.
Okay. Mr. Bell, did you want to continue?
Threw you off track there. Didn't mean to throw you off track.
Totally thrown off beam, and I can't remember what I was going to say. I think I'm at the end of it, yes.
Okay.
If there's anything else, we can pick up further down the agenda.
I was going to say, if something reoccurs to you, Mr. Bell, we can come back to you. Mr. Heinsohn, do you have a contrary view or anything you wish to add or comment on Mr. Bell's response to my question on national developments?
Not particularly a country view. Again, largely in agreement. I think with National Planning Framework 3, pumped storage schemes were national developments at that time, as was the transmission network. Sorry, we've said transition so much, I nearly called it transition network there, sorry. Transmission network, and the importance of those, national importance of those for delivery of renewable energy developments and the storage of renewable energy to help on the path to net zero as it then was. this is the first time, obviously, we've got other types of renewable energy developments identified as national scale developments. And in relation to that, it's when we were previously considering renewable energy development, in terms of the scale, we would quite often use phrases like it's a modest contribution, it's a meaningful contribution, it's a significant contribution, those kind of things. I think that phrasing is probably taken away with the fact that they've been designated as national developments. I think everything in this category would now be a meaningful development. But in terms of how the policy would be applied, the other policies would be applied in relation to the national development. National developments effectively mean that there is support in principle for that type of development. But again, there needs to be consideration of those detailed matters set out in other policies. And fully agree with Mr. Bell in terms of what he said in relation to policy 1 and policy 11 in relation to the significant weight that has to be applied to the climate emergency and those matters of the renewable energy targets. I think that's possibly where the kind of balance has changed. That's the only place where the balance has changed in relation to those policies. In relation to policy 4, which was highlighted 4C in particular, considering it specifically for this case in relation to the special landscape area, and Ms. Anderson gave evidence on that at the earlier sessions. And in relation to 4C2, it's the social, economic, or sorry, I've lost my reference to that. Social, economic, or environmental. Yes, thank you. And the environmental benefits. Obviously, there would be environmental benefits in terms of the contribution in which this would make towards the climate emergency, in terms of and renewable energy targets. But it's consideration of any other environmental matters that may be pertinent as well. But Highland Council haven't advanced a case on environmental benefits in relation to this one, so we're not going to go down that route now.
Thank you, Mr. Heinsohn. Shall we rest our discussion on national developments there and take a break for 15 minutes? If we can come back very precisely at 11:18, and we will move on to NPF4 Part 2 and that part of the agenda. Okay, thank you all and see you at 11:18. Welcome back, everybody. It is 18 minutes past 11, very prompt, and we will resume our session on policy matters. As indicated before the break, we're now going to move to National Planning Framework 4 Part 2 and have some discussion around the individual policies which we feel are most pertinent and about which we would like more of your views. Could we initially turn to policy 1 of NPF4, which is tackling the climate and nature crises? So if you could all move to the relevant page of NPF4, which I will tell you is page 36. So, beginning with Mr. Bell again, at paragraph 4.1.40 of your hearing statement, you set out that you consider policy 1 to be a radical departure and a step change in the planning policy response to climate change. And I did note that you also say that the matter of weight is no longer at the full discretion of the decision maker, given NPF4 and policy 1. Mr. Heinsohn, I note that at paragraph 2.8 of your hearing statement, you consider that the weight to be given remains a matter for the decision maker. Could we start, Mr. Bell, with a look at why you think there is such a radical change or a radical departure, in your words, and a step change in the response to climate change as set out in policy 1?
Thank you. I think in answering that, some of the points I referred to earlier in the statement of need and around the importance of national developments for the delivery of the spatial strategy will be relevant. I won't repeat that. Okay. I think it's radical because of that very point that the government is not leaving it to the discretion of decision makers. It is telling decision makers that when considering development proposals, significant weight will be given. It doesn't say should or may. There's been a tightening up of the language used in NPF4 revised draft since the draft. And if we look at the policy intent to encourage, promote, facilitate development that addresses the global climate emergency and nature crisis, the development would do that. I think another important point is that this is separate from the specific contribution of our development to targets where additional significant weight is to be directed. So there's two areas where the discretion has gone, and it is the approach that has to be followed as clearly set out.
Could I add to that, ma'am,
yes,
if I may? I think when you compare NPF4 with SVP, the other difference is, of course, that the concepts of the global climate and nature crises were not articulated in that way. They're probably known about, but not articulated at all in SVP. These are new creations of NPF4. That's the other. You have to. I think you have to read that whole sentence together. Significant weight will be given to these factors: the global climate and nature crises, the twin themes of NPF4.
Okay. Thank you, Mr. Trinick. Mr. Heinsohn, do you have any comments on that point?
Just briefly, absolutely agree. Significant weight will need to be given to the climate and nature crises. But what policy 1 doesn't necessarily do is restrict the weight to be given to any other consideration. So, for example, landscape and visual, but we'll obviously come into that in policy policy 11. So that's where I believe that the decision maker still can attribute weight. But absolutely significant weight should be given to will be given to the global climate and nature crisis, not just on renewable energy developments, but all types of development.
Thanks, Mr. Heinsohn. Mr. Bell, that's an interesting point, that significant weight would be given to the global climate and nature crises in terms of assessing developments such as the proposed wind farm at Cairn, Duhie, but that doesn't negate the weight given to other matters. Do you agree with that, Mr. Bell, or do you think that policy 1 means that the significant weight to be given to the global climate and nature crises, for want of a better phrase, trumps the weight given to other policy considerations?
I think it would depend on the circumstances of a case and what other policies are engaged. Because if, for example, it was a wild land matter we were dealing with, there is clear direction on how to treat certain effects. We also know that's the case when we look at policy 4 in terms of local landscape areas. We also know that relates to peatland and so on. So there would be a need to examine the particular issues arising in a given case and the effects that were resultant from a development. But that takes us back to policy 11 as the lead policy, which tells us that in considering these effects, significant weight is given in addition to the contribution of the development to targets. So we get guidance through other policies, but the lead policy is important in directing the decision maker to that overall balance alongside policy 1.
Could I add to that, ma'am, that
Yep.
this may go in some to the heart of the debate in a number of these hearing sessions, that I acknowledge what Mr. Heinsohn says and I respect it, but of course there is always a planning balance. Of course you have to give weight to what's on the other side of the balance. But what NPF4 tells us, that the way in which that balance is to be struck has changed. And measuring, as policy 1 says, giving significant weight to the global climate and nature crises, as opposed to the local environmental effects, say landscape and visual effects of the development. And again, we have to know that NPF4 is the policy instrument to achieve the legal obligations of net zero. SPP clearly was not. It's an entirely different document in that sense. So yes, I think we do say that the point on the planning balance scale at which local effects may start to outweigh the need case has dramatically changed as a result of NPF4. Now, I don't say that Highland Council may not have applied that approach in practice in recent years and in some cases, but as I said before, we're not addressing what Highland Council may have done. We're addressing the difference between NPF4 and SPP and its approach to the balance issue. And so we say yes, the way in which the planning balance is struck has dramatically changed as a result of NPF4.
Okay. Thank you, Mr. Trinick. Mr. Findlay?
Well, it won't surprise you to hear that we disagree with that. What policy 1 does is and echoing a point Mr. Heinsohn makes, it makes it clear that this covers all development proposals. And one of the new points is that whilst significant weight was given not just by Highland Council but by reporters and Scottish ministers in the decision-making process to the global climate crisis in renewable energy developments before, policy 1 is making sure that that occurs to all development proposals. The other thing that policy 1 does is it elevates the nature crisis for the first time to an equal standing with the global climate crisis in policy. But simply don't accept that this policy taken by itself suggests that the balance that is required elsewhere has changed. So that's a matter no doubt we'll deal with in our closing submissions. But I want to make that clear that and that the fact that development proposals were given significant weight both by Highland Council and by reporters and by Scottish ministers is a continuing factor, and that's part of our theme of our response.
Stronger way.
Thank you. Mr. Trinick?
Thank you. Yes. Mr. Penny says that the nature crisis has been elevated for the first time to sit alongside the climate change crisis. But actually, that was my point, that even the climate change crisis has been elevated for the first time to be recognised in national planning policy. It wasn't in the SPP. So both have been elevated to a new status. Secondly, it's not just policy 1. We have to read policy 1 and 11 in this case together. And that is what underpins my comment, that the point at which the balance tilts between yes and no on the planning scale has changed as a result of NPF4. I'd also ask you to note Mr. Seaton's comments in the Rothers 3 CD 933 report, paragraph 281, where he says, if you forgive me for reading this, I think it's central. We refer to the specific requirements to strike such a balance in respect of landscape and national energy policy. Furthermore, no one particular development is by itself necessary or sufficient to achieve the statutory targets. However, the urgency in meeting those stringent targets set for the purpose of avoiding dangerous climate change must necessarily affect the balance to be struck. This is so for every particular development. He goes on to acknowledge, which I drew attention to earlier, that he's changed his mind on this point since Scotty Clay. He recognised just the point I'm making, that what is happening and what is now being formalised in the development plan, that's from February the 13th, NPF4, has changed the way in which the planning balance is to be struck. So that's going to remain a point of disagreement, but it's quite an important point to resolve, I think.
Okay. Thank you, Mr. Trinick. Any final comments from the council on Mr. Trinick's last comments?
Just very briefly to say that we have obviously seen what Mr. Seaton has said, and I already alluded earlier to the fact that the Scottish Minister's decision doesn't necessarily accept all his conclusions on that basis. So no doubt that will be dealt with in closing submissions.
Thank you. Are we content that we've explored the implications of policy 1? If so, I'm happy to move on to policy 11. And forgive me, I'm just going to scroll down on my screen to come to policy 11 of NPF4. If we are all on page 53, which is policy 11, energy. This policy addresses all forms of renewable energy development in Scotland, including onshore and offshore, and particularly wind farms, which is pertinent to our discussions today. I noted that Mr. Bell has interpreted policy 11 as being expressly clear in its support of renewable energy and the significant weight to be given to such proposals by decision makers. I noted from Mr. Heinsen's hearing statement that he appears to agree with that position, and I was looking at paragraph 2.9 of his statement there. Is that the case, Mr. Bell? You consider it expressly clear?
I think it is clear, yes. I'm happy to expand on other points within it, if you find that helpful.
Yes, that would be. Thank you. My next kind of sub question on policy 11 was the criteria as set out, A to F in policy 11. So if you're both content with that initial broad question, I can move on to the specific criteria that I'm interested in discussing this morning. First, turning. Yep.
So I just said one or 2 points just about the spatial approach before getting into the specific criteria.
Absolutely.
And that was simply to highlight that policy 11A, its development proposals for all forms will be supported. So it's in principle support at the start of the policy. And I think the big difference is that obviously the spatial framework groups 1, 2, 3 has gone. But part B states proposals for wind farms in national parks, national scenic areas will not be supported. So that is the only carve out in terms of spatial areas. The government's really saying in all other areas, there is in principle support. Development will be supported, subject of course to some of the other policies that might be engaged. So I just wanted to highlight that point in terms of the spatial planning approach that's quite different now. Thank you.
Thanks, Mr. Bell. Mr. Heinsohn, did you have any comments on that, particularly in relation to parts A and B?
Just absolutely acknowledge that it is supported. It's in principle support, as Mr. Bell set out, and obviously there's the considerations that need to be gone through. And I think in removing the spatial framework, while it may not be specifically set out that we've got the Group 1, Group 2, and Group 3 areas, effectively what we've got now is Group 1, and everything else is then Group 3. If we go back to the old spatial framework approach. So there's that support in principle for all other areas out with NSAs and national parks. But obviously the spatial framework is gone, but effectively that's what we are left with. We're left with Group 1 areas, and then everything else being Group 3 areas, and everything in Group 3 areas previously. There was that effectively in principle support subject to detailed consideration of proposals.
Thanks, Mr. Heinsohn. Mr. Findlay, did you wish to add anything? No. On the agenda, I had mentioned specifically Part E2, but if possible, I would like to briefly look for some clarification on Part C, which relates to maximising net economic impact, and I apologise for not mentioning it specifically on the agenda, but I did note from Mr. Heinsohn's hearing statement at paragraph 2.9 that there is a reference to it, but I remain unclear as to whether or not it's the Council's position that this proposal has demonstrated that economic impact is maximised. I know Mr. Bell in his hearing statement has referred back to the planning statement, which was submitted some time ago, and also the relevant chapter of the EIA, which addresses economic matters. Is it possible, Mr. Heinsohn, to clarify the Council's position on that matter? If it isn't, please tell me, and you could address it in closing submissions.
I would suggest that because it's the concept of maximising net economic impact is a new one for onshore renewables. It's been established in offshore renewables for some time, in the way that things are taken through marine licensing. What the environmental impact assessment economic chapter says, from my recollection, that there will be some local benefits, but I don't think it quite sets out that they would be able to maximise economic impact. But I think further guidance is probably required in relation to that maximising net economic impact, to assist in interpretation of that aspect of NPF4.
Thank you, Mr. Heinsohn. Thank you. Mr. Bell, anything on that point? I have taken on board your hearing statement and what it says about maximising net economic impact, but I think Mr. Heinsohn's point about guidance and how you actually demonstrate that to a decision maker is pertinent. So if you have any comments, that would be useful.
Yes, I think there's probably a number of areas in NPF4 where it would be helpful to have transitional and other guidance, and we know that's coming. But certainly the government's indicated that on biodiversity, for example, that there will be guidance produced by Nature's God. There may be guidance coming through the sector deal in terms of economic benefits for renewables. What we have done is set out the benefits in the EIA documentation and in my chapter 6. So the headline figures are there in terms of construction, employment, investment. I think what I could add is the various points I made about the Just Transition Plan and the government's, we talked earlier about that, and I took you to the various references where it's clear that the government sees onshore wind as significant contributor to the just transition, because projects will be coming forward all over Scotland in rural areas. There's no other land use type that's delivering that level of investment in rural areas in Scotland. So for rural revitalisation and local economies beyond the urban centres, this will be an important level of investment. I think what we can say in terms of the applicant is that they do progress initiatives such as supplier engagement days and meet the buyer events, which seeks to maximise the capacity of local suppliers to participate in the procurement and supply chain for development. So, for example, I can also say that contractors such as RJ McLeod, INH Brown, Monroe's near Inverness, they've all been engaged by the developer in other projects. So there certainly is an approach to engage Scottish and local contractors where possible and to seek to maximise that through that type of event. But I think a lot of the points in the onshore wind policy statement are still to be developed by government. And one point in particular is one paragraph I didn't mention in my list. I think it was 4.2.3.
4.2.3.
That's the reference. Sorry, it's the wrong reference. It was the reference to the supply chain, which is 5.2.4 in the onshore wind policy statement, where it states Renewable UK are currently working to fully understand the supply chain opportunities for Scotland. We expect their report shortly and will use it to inform our approach to maximising supply chain benefits. So we can see there that the government is to issue guidance in relation to that shortly.
Right. And when that guidance comes, it obviously will assist decision makers. And in the meantime, I think we probably will have to rely on the EIA chapters and the information submitted to date in the absence of any other guidance. So in terms of part C of policy 11, I'm content that I understand your respective positions. Could we move to part E of policy 11, which is addressing the impacts of proposed energy development? The policy says, and I will quote, that in considering these impacts, significant weight will be placed on the contribution of the proposal to renewable energy generation targets and on greenhouse gas emission targets. I'm referring in total to part E, subparts 1 to 13. I don't think we need to go through each potential and possible impact, but I would like to begin with a higher level discussion on the initial part of part E, which is demonstrate how the following impacts are addressed. And I noted from that wording the absence of other wording, which is resolved or mitigated. Is there anything in particular we should take from that wording? And if we could start with Mr. Bell on that point.
Yes, I think we can take something from that. It's demonstrate how the impacts are addressed. So that goes to the supporting information that will be necessary to show the decision maker how a particular impact has been addressed. And then it's the paragraph that follows the criteria that states in considering these impacts. So the decision maker has got the information on the impacts on all these topics, and they may vary, of course, depending on the particular project, whether it's a solar farm or a battery project or a transmission line. And in considering the impacts, the decision maker has to give significant weight on the contribution of the proposal. And that is the balancing approach. So I think they're distinctly different. E is how the impacts have been addressed, and then it follows up towards the end of Part E with guidance on how the impacts are to be considered and the weight to be applied.
Thank you, Mr. Bell. Mr. Heinsohn.
Sorry, the final thing I would just say, sorry, on that is that I think it's important on item E2 to have the read across to section 3.6 of the OWPS, which I covered it earlier, which talks about the taller, more efficient turbines, the change in the landscape that's underlined, and the specific reference to stronger weight being afforded. And I think that has to be considered alongside the application of policy 11, in particular part E2. And that's specifically relevant to this case.
Okay, we'll come on to that in a moment. Mr. Heinsohn, could you, again, if you have any comments on whether or not Part E and the wording at the very beginning of it is in any way significant in that it's addressed rather than resolve or avoid or mitigate?
I think it is significant in the way in which it actually doesn't provide a policy test as such. Similar to Para 169 of SPP, there was no policy test in that. It lists the considerations, and as Mr. Bell set out, it sets out that significant weight should be given to renewable energy and greenhouse gas emission targets. But it doesn't attribute weight to any of the other matters, albeit it does give guidance in E2 as to what may or will generally be considered acceptable. I think it's important to set out that it will generally be considered acceptable. I think that's the one part really of the following criterion, not criterion, following policy considerations as part of this, where we do have some guidance, and it does set out whether it's appropriate design mitigation and whether that's been applied. And in relation to the other matters, there's not the guidance there in those considerations. Therefore, it is a matter for the decision maker, and like the point that I made on when we're discussing policy 1 before, it is still in the gift of the decision maker to give significant weight to matters, other matters in that policy, other than just the contribution towards renewable energy targets and greenhouse gas emissions.
Okay, thanks, Mr. Heinsohn. Would it be fair to say then, so what you are saying is that significant weight would be given at the outset to the contribution of the proposal to renewable energy targets and greenhouse gas reduction targets. That doesn't preclude the weight you might give to other considerations that might arise in determining a particular proposal. Is that a fair summary?
That would be a fair summary of position, yes.
Okay, thank you very much. Moving to part 2 of part E of policy 11, which states, and I'm going to quote again, significant landscape and visual impacts, recognising that such impacts are to be expected for some forms of renewable energy. Where impacts are localised and or appropriate design mitigation has been applied, they will generally be considered to be acceptable. We have had the inquiry session into landscape and visual impacts and heard from both of your expert witnesses. So I don't wish to revisit the specific positions of the parties because we are well aware of the difference in your respective views. But I would like to broadly discuss part 2 of E. And I think, Mr. Bell, you had begun to discuss that. Again, I don't need to hear the specifics of the landscape and visual impacts of Cairn Duhie wind farm proposal, but in terms of the implications of part E2 for decision makers, what your views broadly are. Mr. Bell, would you like to start?
Ma'am, I'm going to come in on that, if I may,
Yep.
on this particular criterion, or factor rather. First thing to say is that looking at the wording of E2, it starts significant landscape and visual impacts, etc., and then where impacts are minimised. I've inserted in my own mind the word significant before impacts in that second sentence. So in other words, where such impacts, significant impacts, are minimised, localised rather. Right or wrong, that's what I've done. I also note, of course, it's and or appropriate design mitigation. Looking at what localised might mean, first of all, I think it's a separate issue from policy 4D, which advises on the SLA in this case. You could perfectly well have, we say we don't, you know that, have a significant adverse effect on the integrity of the SLA, and yet still only have a localized impact. They're two separate issues.
Okay, I take that point.
The next one, I mean, obviously all commercial wind farms have significant effects, we know that. I think over the last 30 years or so, we've all acquired an understanding of the likely spatial extent and other qualities of these effects for any particular scale wind farm. So I guess when I see the word localized and noting the reference to design mitigation, I ask myself, I suppose I should say, I would ask myself, if I were a decision maker, if the spatial extent and other qualities of significant effects, for example, any perspective distortion, are such that they would be above and beyond what you would expect from a wind farm of this scale. In other words, do they stand out from the norm? Are they different in kind, in spatial extent, in intensity? Or are they what you would inevitably expect? That would be one approach I would take to the issue. Clearly, so therefore, if you have a wind farm where landscape effects extended a lot further than you would normally expect geographically, you might start to ask questions about, are they localized? But if they're what you much as you would expect, and it's really no surprise, then I would start to come down on the side of localized effects. Because I don't think it's possible for it's not one size fits all. You can't say what is localized for a 2-turbine wind farm is the same as localized for a 50-turbine wind farm. It depends on the scale. You know our evidence in this case, I'm not going to go into that. On the question of design, the other part of E2, you've got Sam Ox's evidence, I'm not going to go into that, but I do take you to the report of handling of the application, CD34, where at paragraph 859, there were positive comments made by the planning officer about the design of this extension, and I'll leave you to read those. So we say that mitigation has been properly addressed and applied. Thank you.
Sorry, can I just
Thank you,
ask Mr. Trinick, you made the point that you didn't actually say anything more about it, about the fact that this consideration talks about and/or. So do you think that phrase means you can just do one or the other. You don't have to do both.
I'll hand over to Mr. Bell for that, if I may. Mr. Bell, yeah.
It may well do. And what it's not saying is that the effects just have to be localized, because it's fairly rare to have certainly a development of scale over 50 megawatts where you're only having localized effects. So I think it's both considerations will come into play generally in a determination.
So the if you had said, if you're saying that appropriate design mitigation has been applied, you're not saying that's enough, then, you know, if you say we've done the best we can here, tough. You're not saying that.
No, it may well be if you have appropriate design mitigation, but you've got fairly extensive visibility of some aspects of the scheme, that may still be acceptable.
Mm-hmm. Mm-hmm.
Thanks, Ms Hayward. Do the council have any comments on that exchange? Mr. Finlay?
Perhaps I could come in
Indeed.
first. Just picking up on the last point that Mr. Bell made, that the advice given that where impacts are localised, generally proposals will be considered to be acceptable is positive advice in a particular circumstance. It doesn't give you any advice for anything that lies outside those circumstances. So it's not telling you that development which has impacts which are more than localised will be unacceptable. It's leaving that open. So it's giving you specific advice to a specific set of circumstances. The second point is what is localised is a matter of judgment, and I agree with Mr. Trinick to a limited extent that the judgment will depend upon the scale of the proposal, so that that would be a factor you would take into account in judging whether impacts are localised or not. But where I disagree with Mr. Trinick is the suggestion that you can read from this that the normal, insofar as there are normal impacts from a large-scale wind energy proposal, will always be considered to be localised. I don't see you can get that at all from this wording here. There are many instances, and Mr. Heinsohn's referred to them in his report, where reporters and others and Scottish ministers have concluded that impacts are localised or local, and that has clearly been a factor in their favour. And it seems to us that this is effectively putting that in express form. So that in terms that is our the overall approach is that you should expect some significant landscape and visual impacts, and again come back to the point that I think in almost every inquiry Highland Council accepts that there will always be some significant landscape and visual impacts from a turbine or wind farm that has turbines of the scale proposed here. So that's, if you like, nothing new. The two further points, the use of the words and or, won't go into the legalistic, but there's some Scottish legal opinions very rude about the words and or, because it's not perhaps as clear as it might be. But read sensibly, if you have impacts that are simply localised, then the proposal may be acceptable. Or it may be where they are more than localised, but appropriate design mitigation has been provided, and that's named different from the position that's existed in the past. They may be acceptable. The question is, what is appropriate design mitigation and what are localised? I'll come back on matters of judgment. And lastly, just to come back to Mr. Trinick's first point, I do suggest that it's very unlikely that if a proposal has an impact on the integrity of an SLA, that it would be considered to be localised in impact. I'm not saying it couldn't occur. It would depend upon the SLA, but I think that's also reading too much across to other policies. It should be applied in a straightforward fashion, leaving matters of judgment to the decision maker. But it's generally telling a decision maker what will be acceptable, not in specific circumstances.
Thank you, Mr. Findlay. Mr. Trinick?
Thanks. On that point of the relationship between policy 4 and policy 11, Mr. Findlay will be right in practice that in a number of cases, if you have significant adverse effects on the integrity of an SLA, then the effects may not be localized. But that can happen, especially, shall we say, if you have a relatively small SLA. I don't know. I don't want to give examples. I'm just drawing attention to the fact the policies are separate. You cannot apply 11E2 alongside P4D. They are two separate policies. The other point to make, I think, is that yes, I agree with Mr. Findlay that the words and or give rise to all sorts of difficulties, but I read it that yes, you can have localized impacts, and if they are, they'll generally considered to be acceptable, or you can have impacts which are not localized, but where you have applied appropriate design mitigation and it may be considered to be acceptable. And of course, there's a relationship between the each side of and or, that you may well have made the effects more localized by applying appropriate design mitigation. So it's an interesting sentence which no doubt will debate over time.
I wonder if I can add just a
Mr.
couple.
Trinick.
I wonder if I can add just a couple of points in conclusion. I think we need to remember that this policy is not just for wind energy. It applies to solar, battery, overhead line transmission projects as well. And certainly in terms of battery projects, some of them are 250 megawatts in scale, in major structures in the countryside generally. And in my experience of transmission work such as the Sky Reinforcement Project, it's turned out in the LVI there that a lot of the effects are localized in terms of the NSA and so on. So I think we need to bear in mind the wider context for the application of the policy. And it's actually quite rare in my experience to get a wind farm where the effects are just localized. I think there's one or two, Margree and Dumfries and Galloway. I think the reporter commented specifically on the localized nature of effects. It's quite rare to get that. And the last point to bear in mind, I would say, is the sheer scale of the target. If Scotland is to deploy effectively 130% more of what it currently has, it's inevitable that the landscape will change and there will be quite a dramatic change potentially in some areas. And that's what the onshore wind statement tells us. So it was just to put that sort of wider context for the application of that policy and what the author will be trying to address as well in terms of other technologies.
Okay. Thank you, Mr. Bell and Mr. Findlay. In looking at the balance of policy 11 and the other criteria, I'm satisfied that the written submissions of the parties and the statements address those matters that need to be addressed. So I'm happy at this point to move on to policy 4 of NPF4. And if you could just give me a moment while I bring up the relevant page. So I'm taking you to policy 4 natural places on page 40 of NPF4. We're now on to the third bullet point of the agenda under NPF4 part 2. In relation to policy 4, again, I would reiterate that we have already had a landscape and visual impact inquiry session. So it really is a broader discussion than the specifics of the Cairn Duhie wind farm proposal. In particular, I was looking at Part D of Policy 4, and I noted that, Mr. Bell, in your hearing statement, paragraph 4.1.78, you consider that it's in effect a new policy provision, in that adverse effects must be balanced against the benefits of a proposed development. And I wanted to perhaps hear from you about how that is actually new. Is that not what decision makers have been doing under NPF4 and SPP and the LDP in reaching decisions on, in particular, wind farm proposals, but renewable energy proposals?
Yes, there has been a balance, but this is the first time that there's been a policy set out like this with such a test. And in SPP, it's quite general guidance to give appropriate weight to local landscape designations, and it made it clear that it would be less than national. It didn't go much further than that. So now we have an approach where we know from Policy 11 that there's support in principle for wind energy in these areas. The way in which the policy has been constructed is broadly mirroring the approach that we've had for national designations that we had previously in SPP 212. And there are, as I've set out in my hearing statement, there are two limbs to the policy. And I think it has to be approached also from the perspective that there is a consented development at this site as well. So bearing that in mind. But the first limb, it makes it clear that development will not have significant adverse effects on the integrity or the qualities. And if there is such an effect, development will not be supported. Now, I won't go over the evidence, but Ms. Oxley was clear in summary that, in her view, the special qualities and the integrity of the SLA would not be significantly affected. So if that evidence is accepted, then the development should be supported. In the alternative, if that evidence is not accepted and it is considered that there is an adverse effect on integrity and the qualities, then the second limb is engaged and it's necessary to go there. And it tells us that if the adverse effects, any adverse effects are clearly outweighed by benefits of at least local importance, then development can be deemed acceptable if it has such an effect on the integrity of the area. It doesn't mention special qualities, but I think that's probably just a drafting error, because and certainly integrity would be a higher level of impact than simply one effect on a special quality. And in this case, the development is nationally important and would deliver benefits of more than local importance. The benefits would be of national importance. So if we needed to go to the second limb, then the applicant's position is that the proposed development should be supported as it would pass that specific policy test.
So, Mr. Bell, so what we're saying is because of the nature of the proposal at Cairn Duhie and under NPF4, it would be a national development. Are you saying that when it comes to Policy 4, Part D, Part 2, the presumption is that the social, environmental, or economic benefits are automatically more than local importance?
I think that's an obvious consequence of the way the policy is constructed and the definition of national developments, yes. And it fits the pattern of what the government is doing. I mean, I think the government recognises the target is, quite frankly, immense when you consider what has to be achieved within 7 years. And the explanatory report that goes along with NPF4 sets out that in terms of we know wild land areas, the government stated that the policy has been relaxed, essentially. Otherwise, targets would not be met. And I think we can see a number of areas in NPF4 where the spatial guidance and policy has been amended to enable national development to be deployed in line with the statement of need. Of course, that doesn't, in terms of other aspects of policy, guarantee a consent. Nobody, I think, on this side is stating that would be the case. But there's clear policy direction, which I think is clear to read in Policy 4.
Okay. Thanks, Mr. Bell. Mr. Findlay and Mr. Heinson, could I have your comments on that? In looking at Policy 4D 1 and 2, what is your position on what Mr. Bell has just said and the applicant's interpretation of those two parts of Part D?
Perhaps if I start and then ask Mr. Heinson to deal with the last point about the relevance of it being a national development.
Yeah.
First is by way of contrast, to make the point, to draw your attention to Policy 4A, which requires a balancing exercise, not an unusual one, which is neutral in its terms. Something is either acceptable or unacceptable. If you turn to Policy 4D, it is new, and it provides a change as to how local landscape areas were dealt with before in decisions respecting renewable energy, and it's because it's expressed in, because of the way it's expressed, that they will only be supported if they achieve one both criteria. If they don't achieve criteria 1, they have to achieve that, or criteria 2. So it's a strengthening of position. I think it can perhaps contrasted with what Mr. Bell said about wild land areas. This is a definitely a strengthening of position. The little Roman numeral 1s doesn't require further discussion. I agree with Mr. Bell that Roman numeral 2, the reference to special qualities also needs to be included there as a matter of common sense. It must cover both integrity of the area and its special qualities, if it's the special qualities that have been identified as being significantly adversely affected. And indeed, just alluding to our case briefly, I think Miss Anderson's evidence, she gave no evidence in effect on integrity, but she did give evidence on the qualities which it had been identified. The next point to note is that it's a, if you like, a reverse tilted balance test. If there are significant adverse effects, they need to be clearly outweighed, not just outweighed, but clearly outweighed. So that's language that's similar to what is in paragraph 33 of SPP at the moment, but applied in a slightly different mechanism, but it's still there. And then you get to the point of benefits of at least local importance. So there's still the balancing exercise. D2 clearly imports a balancing exercise. And then I'll pass over to Mr. Heinson if he wants to add to that and to deal with the point about the development being raised as or being a matter of classified as a matter of national development, which is a point just to note. I'd quite like to come back, having thought about your questioning on that at the end of this session, if I can, to make one further submission and ask for 2 further documents to be put in. But I'll deal with that in due course. I don't think it's going to cause any problems.
No, hopefully not. Thank you, Mr. Findlay. Mr. Heinson?
Yeah, I think just in relation to when developments are set out as national developments, on policy, page 97 of NPF4, electronic page 98, it sets out that the designation is not intended to describe in detail how the project should be designed, matters to consider or impact assessments and mitigation to be applied. So in taking that into consideration, it's not necessarily saying that just because something's a national development, it would necessarily have benefits of a national scale, because you've still got to consider those impacts and the mitigation to be applied on a case by case basis. So it's just really to draw attention to that matter, and obviously the evidence on that is within the environmental impact assessment report.
Okay. Thank you, Mr. Heinzen. I'm satisfied that we've probably talked as much as we need to about policy 4. There are other relevant policies within NPF4, and the parties have referred to those in their hearing statements. Are there any comments from the parties on any other policy within NPF4 that we haven't discussed today that they would like to make at this stage? Otherwise, we will rely on your written submissions. To the applicant first, if there is any other point on the policy, specific policies in part 2 of NPF4.
I'll leave that to Mr. Bellman, but I think on policy 4, I want to say one final thing or not?
No, that's fine.
No, it's okay. Final policy 4, apologies.
Okay, thank you.
In terms of other policies, I think we've covered the principal ones of relevance. Thank you.
Okay. Mr. Finlay and Mr. Heinzen, anything to add on any other policies of NPF4? You're happy to?
No, we're happy to rely on the hearing statement.
Thank you both very much. I think we can conclude our discussion specifically on NPF4 and parts 1 and 2. But before we finish this particular part of the agenda, I wonder, is there any sort of headlines that we as reporters and decision makers should take away from NPS4? I appreciate that's a fairly broad question, and we have covered a lot of your thoughts on the broad intent of NPF4, but as a parting shot almost in terms of NPF4, are there any particular headlines you think that we should bear in mind? And if we could ask the applicant first.
Yes, I would say there's maybe four points. The first one is the answer to the question, is this a significant change in planning policy and approach? I would say yes. We know, and I've referred to the minister's statement in Parliament, the planning minister stating that this is the biggest change to the planning system since the 1947 Planning Act. So the government views this as a different approach. Secondly, I think the government has delivered on the rebalanced planning system that was referenced in the draft of the NPF4. I think thirdly, the twin themes of the nature crisis and climate crisis are important, and in that regard, the habitat management and enhancement actions that are proposed and which would be secured by way of a condition are important. And then lastly, I think the headline point would be the read across to 3.6 in the onshore wind policy statement. It's no coincidence the documents were produced around the same time and the direction for stronger weight to benefits. Thank you.
Thank you, Mr. Bell. Mr. Heinzen, are your views similar on what we should headline from NPF4 or anything contrary or additional?
I don't think there's anything necessarily contrary. I do believe that there is a shift in policy wording, as I set out earlier, not necessarily in relation to how policy had necessarily been applied. We've covered that point already. In terms of recent decisions under SPP and NPF3, while Mr. Bell set out or explained the statement by ministers that this is the biggest change since 1947. I believe we heard that in relation to Scottish planning policy as well when that was released. We've heard that quite a few times, but it is a change in terms of the policy wording and the emphasis in the policy wording. And I've got no further comment in relation to the habitat enhancements and biodiversity and tackling the nature crisis. I think that's the tackling of the nature crisis is equally as important as the climate crisis, and I think that's highlighted through the inclusion of both of them within policy 1.
Thank you very much, Mr. Hanson. Mr. Finlay?
Perhaps I could add to that that it's difficult to sum up a headline change. One can do it in respect to the document as a whole, and then Mr. Bell's reference to what the minister said about it is appropriate. But our primary case is that the concentrating the headlines is not what's important in this case. It's concentrating on the detail and the extent to which the detail suggests a real change in approach is important. So whilst not seeking to hide away from the question, I don't think there'll be much in our closing submissions on headline changes, because it's the actual changes that are of importance.
Okay. Right. Thank you, Mr. Finlay.
If I may just...
Yeah.
I disagree with Mr. Finlay there. I think actually that we can get so absorbed into looking at the individual words of policies and trying to pass them and discuss them on what they mean and apply them, that we may actually miss the major point of NPF4, which is the headline. This is a step change. It is a rebalancing. There are twin themes of climate change and the nature crisis. No, I disagree. I think we do need to look at the headlines as much as the wording of the policies.
I think somebody has their microphone on who possibly shouldn't. I'm getting intermittent noises. Thank you. Right, I think before we break for lunch, if we finish this part of agenda item 2, and I'm going to come back to the Chief Planner's letter, which I had mentioned earlier in the agenda and skipped over to address now. In looking at National Planning Framework 3, Scottish planning policy, and their continued relevance to the assessment of this application, I just wanted to broadly say that we are content with your written submissions. They have already addressed NPF3 and SPP, but a brief overview of each of the parties' opinions on the continued relevance of those two documents would be useful. I have in mind the advice of the Chief Planner's letter of January 2023 and the proposed adoption date set out in that letter of mid-February 2023, and also the target date for this report to be submitted to ministers. Could I first have some comments from Mr. Bell and then moving on to the Council? Thank you.
Thank you. Yes, I did look at this in section 4.1 of my hearing statement, and until 9 o'clock in the morning on the 13th of February, NPF3 and SPP will remain in force, and the approved version of NPF4 is to be a significant material consideration. So at the moment, my position, as I've set out, is significant weight to the approved NPF4, which is in the same form as it was introduced to the Scottish Parliament as a revised draft, which we've referred to today, as of after 9 o'clock on the 13th, then it would be substantial weight as part of the development plan, but recognising that Section 25 of the 1997 Act does not apply in this case.
Yeah. Okay.
Thank you.
Thanks, Mr. Bell. And the Council, any contrary or differing views?
No, nothing contrary or differing. 13th of February, SPP and NPF3 fall. Sorry. Therefore, yeah, a significant weight to be attributed to NPF4 as part of the development plan from that time. but they obviously remain in force until that time.
Okay.
I should
Okay,
just
yep.
say that in terms of our closing submissions, which I think are due before the 13th of February, but only about 3 or 4 days before,
Apologies.
I intend to draft our closing submissions on the basis that NPF4 is in force and the others are no longer in force. And that must be the realistic approach for you in writing your report. So I just giving warning that I won't be. So I will be making that assumption if that's appropriate. And obviously, if the earth falls in and something doesn't, and it isn't brought forward at 9 o'clock in the morning, then obviously all parties will need to reconsider matters anyway. But that's the working assumption.
Yes, it's most unlikely, but barring, the sky falling in, which may potentially happen, I would accept that will be the case. Right, thank you all very much. I think this is a rational point at which to stop before moving on to part 3 of the agenda. Oh, Mr. Finlay, I beg your pardon.
Well, I raised earlier that I had been giving some thought to one of your questions, and it was the impact of the proposal being classified as a national development on weight and application of other policies. And it was really twofold. One was to draw your attention to the guidance in the annexes, so that's page 97 on national developments, and what gives some indication of what they are and what the impact of a national development being so described, i.e. that the principle of development does not need to be agreed, for instance. And then Mr. Heinsohn, in answer to you, referred to pumped storage having a national development before. And just by way how that was worked through, the Highland Council does have recent experience of a pumped storage application, which is called Red John, which there was a reporter's report and the minister's decision. And it struck me that may be of some assistance to you in seeing how ministers and indeed a previous reporter had dealt with an item or a proposal that was for nationally recognised development of a type where it's a generic type, such as pumped storage, rather than a specific type, because there will be other examples of specific types. So I was, I'd indicated I was going to ask for 2 further documents to be put forward, and those would be the 2 documents. And really, there's it's only just to show how national development has been dealt with in the past. I will be making brief submissions on that, and I would hope that Mr. Trinick would have ample opportunity to respond to that insofar as necessary in his own closing submissions.
Okay, that would be useful. If those additional documents could be submitted as core documents either today or tomorrow, that would be useful.
I'll do that. I mean, Mr. Trinick may wish to object, but he doesn't look objectionable at the moment.
Mr. Trinick, are you objectionable?
Completely disarmed by that. No, of course not. I'd rather deal with the terms of it rather than try and shut it down.
Okay, thank you.
I'm obliged to the unobjectionable, Mr. Trinick.
Okay, then, if that is all on item 2 of the agenda, we should break now for an hour for lunch, come back at 1:30 promptly, if possible, and then we shall work towards finishing in and around 3, bearing in mind Mr. Heinsohn's obligations. We have part 3, 4 and 5 to run through. I am conscious that part 3 probably will be the lengthiest part of the afternoon session. So if we could be back promptly at 1:30, that would help. Mr. Trinick?
Man, could we take a much shorter lunch break, if that's possible?
Yes, that is entirely possible. When you say, what do you think, 30 minutes is sufficient?
20 minutes, half an hour.
30 minutes?
30.
Yeah. If 20. If everybody's happy with 30, shall we then resume at 1 o'clock?
Thank you.
Perfect. Thank you all very much. Good afternoon, everybody. Welcome back and thank you for your prompt return. It's 1 o'clock and as discussed before our break, we're moving on to part 3 of the agenda, which is national policy guidance and or favourite phrase, advice. In this part of the agenda, we wanted to look broadly at some of the more recent and not so recent energy related guidance and strategy documents from Scottish Government. And in particular, we are going to look at the Scottish Energy Strategy, the Onshore Wind Policy Statement, December 2022, and the Draft Energy Strategy and Just Transition Plan. I do have your written submissions on all of these documents. And what I wanted to explore in this part of the agenda is, do these documents represent a change in emphasis for windshore energy? Not simply a change in emphasis in itself, but in relation to the delivery of this proposal, particularly the change in emphasis in relation to the minimum capacity target set out in those documents for 2030 in Scotland. If I could begin by noting that Mr. Bell, at part 2.4.21 of your statement, you consider that the Scottish Energy Strategy gives unequivocal support for the further development of onshore wind in Scotland. And I note from the Council statement that your position appears to be that the energy strategy should be read in conjunction with NPF4 and the onshore wind policy, which I don't think Mr. Bell would disagree with, but that when the proposal for a wind farm at Cairn Duhie is assessed against those, the balance required to achieve the right development in the right place has not yet been achieved. And I'm looking at paragraph 5.2 of Mr. Heinsohn's statement. Could the parties set out for us how they see the change in emphasis, if you do see a change in emphasis, impacting on the assessment of this proposal, starting with Mr. Bell and then moving on to Mr. Heinsohn and Mr. Findlay? Thank you.
Can I just confirm, are we looking for comments in relation to the energy strategy, the onshore wind policy statement, and the new energy strategy altogether? Just so I could take that as.
You could probably start with the Scottish Energy Strategy, just so I am clear. I mean,
I'll take
I understand they're fully interlinked, but if we can be specific about which document we're talking about, it's easier for my notes and in writing our report. Thank you.
The first one you've referenced is the Scottish Energy Strategy of 2017, CD 007.002. Now, it is going to be replaced by the new energy strategy. The draft is out on that, and the consultation period runs to the 4th of April. And I think what's important to recognise is the 2017 energy strategy refers to the onshore wind policy statement of 2017 as well. We know that's been replaced now by the OWPS of December 2022. I think the big point I would say in relation to the 2017 energy strategy is that it referred to onshore wind as playing a vital role in Scotland's future. And we know from the onshore wind policy statement that the government's now using the language mission critical to targets. So it was vital back in 2017. It's mission critical now. And the big change in the OWPS is the introduction of the target. And I know you've got that as a following on item, so I won't say any more about that at the moment. The energy strategy document, which is the new one, refers specifically to onshore wind at page 64 for your note, paragraph 3.1.2, where it confirms the target and refers to the recently published onshore winds statement. I think that's what I would say at the present time. Thank you.
Mr. Heinsohn, any comments on the change in emphasis, or indeed if you believe there has been a change in emphasis?
Certainly, with regard to the earlier documents, there was support for onshore wind energy through those documents. These documents are continuing to support onshore wind, and absolutely agree. It went from vital to mission critical. How much of a difference there is between those two matters, I would still say it's probably vital. Mission critical could be considered as being vital as well. I think it's probably a nuanced point, that, but I think it's that continued support from the earlier documents to the current documents that we've got there, rather than necessarily there being a significant step change. I would suggest that it's a continued support for onshore wind energy development comes through these documents.
Right. Thank you, Mr. Heinsohn. In terms of how the Mr. Findlay, I beg your pardon.
I was just going to give you perhaps a useful reference where Mr. Heinsohn's approach can be backed up, but that is in the minister's report for the Rothes 3, which is CD 932 on page 23, dealing with very much the same policy framework that you're dealing with here. They say Scotland's renewable energy and climate change targets, etc., etc. I won't read it all out for you at this stage. Remains a priority of Scottish Government, and it's the word remains that I emphasise. And it remains clear that from draft NPF4, as well as the onshore wind policy statement refresh 2021 consultative draft, that this is a matter which should be afforded significant weight in favour of the proposed development. So that's the Scottish Minister's own view on it remaining a case. I mean, there are no one's saying that the targets are standing still or other things are standing still, but in terms of application to the acceptability of a proposed development, that I think gives you a helpful, illustration of a point that Mr. Heinsohn was making.
Okay, thank you, Mr. Finney. Can I just take a page reference from that document from you again, please?
Yes, it's I think it's both electronic page and actual page 23. So the Scottish ministers are now page numbering their reports, which is good. And it's under the second paragraph down from the middle of the page, which comes under the title Acceptability of the Proposed Development.
What if I could come in just on two points to add to the position? In the onshore wind statement, we see at paragraph 1.1.2, we must go further and faster than before. So whatever Mr. Seaton was quite rightly setting out several months ago, the government's now saying we go further and faster than before. And at paragraph 1.3.1, it is vital to send a strong signal and a clear expectation of what we believe onshore wind capacity will contribute in the coming years. And that's about the target. And clearly, the ambition of more than doubling the existing capacity is a very different emphasis, and it's a clear change in policy direction, not just support for more, but actually measuring, putting a measure as to what that additional contribution will be. So I think I would say it's not just a change in emphasis, a subtle, nuanced change. It is a clear stepping up of the importance, such that that mission can be delivered in 7 years.
Okay. Right, thanks, Mr. Findlay.
Yes, just to come back, and that the words I was quoting weren't from the reporter, they were from the Scottish ministers, who actually phrased themselves slightly different than Mr. Seaton did, which is a point I made earlier. And the second point is that I note the words Mr. Bell picks up, and it's one of those cases where there's something in the document that both parties can rely on. But if you look in the ministerial forward, which I think Mr. Heinsohn drew attention to, in the penultimate paragraph, this is of the onshore wind policy statement. There's a reference in the third last paragraph, whilst imperative to meet our net zero targets, it's also vital. It doesn't say mission critical, I accept, but whether there's a difference between the two, I'm not sure, as Mr. Heinsohn suggested. That this ambition is delivered in a way which is fully aligned with and continues to enhance our rich natural heritage and native flora and fauna. And the third point is I'd just like to make is to pick up a point of, in respect of Mr. Seaton's comment in the previous Gulf Clay decision. If there'd been intention to diminish the weight to be given to landscape impact, that would have been expressly said so. And indeed, there have been instances where, and we looked at them earlier today, where particular guidance has been given about localized impacts. But there hasn't been anything more than that. And in our submission, a balanced approach needs to be taken to these documents, which is what is, when read as a whole, the documents themselves require.
Okay. Mr. Trenick.
Thank you, ma'am. I don't think we'll ever see a policy that says we're giving far more weight to X and therefore we give less weight to Y. It is the point I was making. It's an inevitable consequence that NPF4, that in the terms I expressed earlier, and I won't repeat, the way in which the planning balance is to be applied changes. And there was nothing, as Mr. Finley says, that you give less weight to landscape and visual effects. But the planning balance, if you view it as being a continuum, you strike the balance some way along a curve, then inevitably, as a result of NPF4, you give more weight to one thing, you will give less weight to the other. And that's the point I'm making.
I would add, from a planning perspective, that has to be the case. If we're giving a stronger weight, as directed to by the onshore wind policy statement, in considering the impacts in policy 11, then, as I've said before, that means as a consequence, there's an acceptance of a greater degree of harm, whatever that may be, than would otherwise have come about should we have been following, say, SPP. And we know that there's an express direction in policy to take a different approach in terms of wildland and local landscape areas.
Thanks, Mr. Bell. Mr. Findlay or Mr. Heinsohn, any comments?
No, nothing further to what I've said already.
Thank you. Moving to specifically the onshore wind policy statement of December 2022, I want to broadly discuss the implications of the ambition to deploy a minimum installed capacity of 20 gigawatts of onshore wind by 2030 in Scotland, and if, or indeed how, that should affect individual development management decisions. And by those, I mean reporters' decisions and ministers' decisions as well. I note that Mr. Bell has set out in his hearing statement that the ambition of achieving that target is a minimum, but that to achieve it by 2030 is challenging. Could you expand on that, Mr. Bell?
Yes, I think the target itself and the minimum figure is clearly set out in section 1.1 of the WPS. The government has in the table at the bottom of page 5 highlighted that in terms of the 3 categories of development schemes that are in the planning process such as this application constitute about 5.5 gigawatts. Those that are already consented but have not yet started construction are about 4.56 gigawatts, and those that are under construction 1.7. That totals to 11.3. And so if we add the current operational capacity of 8.7, we get to the 20. So some might say, and I've heard it advanced by some parties, well, Scotland's comfortably got what it needs for 20. Well, the government's added some footnotes to that table, highlighting that not all projects will receive consent that are in planning, and that would attach to this consent. But also there's a degree of duplication, and this application is just that, because it sits in the awaiting construction category, but it also sits within the in planning category. So that is an example of the duplication. There's others such as Limekiln. There's several other, I could just reel off, probably tip height extension applications that would feature in both categories. There are also related other constraint matters, whether that's the application has not gone forward for, let's say, a tip height increase, or maybe constrained by Estill-Muir or other matters which mean it cannot progress. So the government's clear that we cannot rely the consented capacity wholly, and that's a consistent position. If we move on from that and look at what needs to be consented and built within the period up to 2030, it is a considerable amount. I estimate 130% of what we've got at the moment. Therefore, that is what I call the substantial hill to climb in my hearing statement. So to get to that target is a challenge, but we know from the energy strategy as well that the government wants to export energy. So page 8 of the energy strategy is called, there's a subheading, expanding our energy generation sector. There's a short paragraph, if I could read it. Scotland's rich renewables endowment means we can not only generate enough cheap green electricity to power Scotland's economy, but also export electricity to our neighbours, supporting jobs here in Scotland and the decarbonisation ambitions of our partners. So there's other aspects to the export ambitions. So the minimum target is not just to meet the statutory emissions reduction targets in the 2019 Act and as set out in the carbon budget. I would say an important point for you to recognise, albeit it's in the draft strategy, is the export potential. And that links to the point about the fastest move away from oil and gas to renewables, not just for the benefit of Scotland and the UK, but for Scotland's neighbours.
Could I just add one point to that?
Yes.
Which is about timing. That wind farm applications take a long time to go through. And even when they're through, they may take a long time to get grid consents. That I don't think anyone would argue that a scheme which is not yet already in the planning system would have a hard struggle to be installed by 2030. That's what the statistics of planning performance in relation to wind farms tells us. If you're not submitted by 2023, I think you're unlikely to make 2030 installed, both for reasons of timing of the planning process, the length of time it takes to go through inquiry and get a decision, and the unknown quantity of grid connection dates, which may be outside 2030 anyway for a number of projects. Thank you.
Thanks, Mr. Trinick. I suppose that gives rise to the question, does NPF4 and the suite of documents in relation to the onshore wind policy statement, a revised energy strategy, will they inevitably make the process easier and therefore facilitate delivery of that capacity in terms of onshore wind energy generation in Scotland? You know, will the new policy approach, and we agreed there has been a change in emphasis and a change in policy approach to almost a universally positive impact on the consent process, one would hope. Will that change that challenge and make it less of a challenge to deliver on the ground onshore energy in Scotland?
Yeah.
And therefore that imperative, which we see now, given our previous experience to date, will that inevitably change given the change in policy context?
Yes, I would say it should do. And that is an obligation now passed to decision makers, because NPF4 is, we know, the policy instrument for delivering net zero, and there are statutory outcomes that link through to the 2019 Planning Act, that of course link to the 2019 Emissions Reduction Act. And we know from NPF4, I'll go to the energy strategy, page 55. It states, and I've quoted this at paragraph 7.3.6 of my hearing statement, that there's a commitment to place climate and nature at the centre of our planning system. I put that in bold, although that's the original emphasis in the document. So I would say that the government has now put in place the policy framework to deliver the statutory outcomes, and has provided the spatial guidance that we as planners, decision makers, need to now follow. And that should make it easier, because the deployment challenge has been set of delivering that 20 gigawatts by 2030. It's not a nice to have, and it could go to 2045. We know that the critical time period is this decade.
Just to wrap up on that, and I'm sorry for withholding the floor on the applicant's side, but I'm perhaps less optimistic and more realistic about compressing timetables for decision making. It isn't just a question of NPF4 saying what the government wants and therefore it will be done. It may facilitate more positive decisions. Whether or not it facilitates quicker decisions is quite another matter. We know the time it takes to get to a Section 36 inquiry and how long it takes you to report. No criticism at all, but it takes a long time. And the ministers then take a long time to deliver their decisions. Whether that's compressed, well, we'll wait and see. It depends on resources. But we mustn't forget that NPF4 isn't just about delivering what the onshore wind policy statement wants, 20 gigawatts by 2030. It's about delivering net zero reductions year on year as a matter of legal obligation, 2023, 24, right through to 2045. That obligation continues, and NPF4 is the policy instrument to deliver net zero by 2045. So I think my message is timing is still a real challenge, and therefore I think there's a real premium on projects which are in the planning system now, because those are the ones that are going to deliver by 2030, not those coming forward in a year or two's time.
Thank you, Mr. Trinnick. Mr. Finlay, or?
I think I'll ask Mr. Heinsohn to deal with his experience, particularly of the time it takes for developments to projects to get through the system.
Thank you. So my understanding, based upon discussions with the industry, energy consents unit, and various others, there's approximately 29 wind energy projects that are not yet in the system in Highland, but will be brought forward within the next 2 years. I'm aware that some of those grid connection dates prior to 2030, with some of them quoting very recently to me that they've got grid connection dates in 2028 and 2029. So they will be able to make a contribution. They're not in the system yet, but based on discussions with those developers, they will likely be in the system by the middle of this year, or at the latest spring next year. And as part of that, Mr. Trinick quite rightly said it comes down to resourcing. A lot of it, the policy framework is being put in place to facilitate these matters, moving forward more swiftly, but it will come down to resourcing, and things have moved on fairly significantly in that regard, with the increase in planning fees and planning authorities across Scotland, not just in Highland, recruiting further staff to be able to deal with the applications more quickly. And there's innovative ways that planning authorities are prioritising schemes as well, where they've been asked to by the development industry. So there is opportunity to still speed up the process, but it comes down to those projects actually coming forward. So I agree that there is a risk of some of those projects not coming forward, and whether they can make a meaningful contribution. But on the basis of discussions that we've had as a planning authority as of late with the development industry, there are still a significant number of projects coming forward in the relatively short term. And for example, Highland Council are going to be prioritising, or have started prioritising, renewable energy developments above others as of late to facilitate the drive to net zero. I appreciate that's not may not be the case across Scotland in terms of how other planning authorities manage their caseload.
Okay, thank you, Mr. Heinsohn. Mr. Trinick, did I see you wish to comment?
Well, just quickly, I mean, just to note that Cairn Duhie does have a grid connection date of 2027. So it's I think it's one of those critical projects with premium quality in terms of delivering 20 gigawatts by 2030. And responding to Mr. Heinsohn, I'm not worried about Highland Council so much. I know that they take this very seriously, and I admire what they're doing. It's when the project gets to an objection, it gets to inquiry, the trouble starts. Far more time is spent from that moment onwards until a decision in comparison to the time it takes to get to the committee of Highland Council.
Noted. My next question relates to the implications for the delivery of Cairn Duhie in terms of the change in emphasis, or the change in the policy climate for the assessment of projects like Cairn Duhie. So the Scottish Energy Strategy, the onshore wind policy statement, and the energy strategy and just transition plan consultation draft. Are there implications that either party can identify now on the assessment of Cairn Duhie? Starting with Mr. Bell.
Yes, I think the discussion we had this morning in terms of the various policies that are engaged by the development, there's clearly implications in how you approach and apply those policies and treat NPF4 as part of the development plan, recognising, again, the caveat that Section 25 is not engaged. So that's a sort of broad answer on NPF4. I don't want to go over the detail of what we've covered with national developments. And then secondly, onshore wind policy statement was an important material consideration, which, as I say, reads across from NPF policy 11 in terms of landscape and visual considerations that are particularly pertinent in this case, given the reason for rejection. And also within the OWPS, the mantra of the target and some of the other paragraph references I mentioned. And in terms of the energy strategy, I would say picking up on the just transition, but that gets more ventilation for this land use type in the onshore wind statement with the paragraph references I gave, and the point about the export potential. So it's not just a minimum target, but the government is looking to export energy to the the continent, the European continent as well. So I think all of these documents together have direct implications for the delivery of this proposal and your determination.
Okay, thank you, Mr. Bell. Mr. Heinsohn?
I don't think I've got anything further to add beyond what Mr. Bell has said out there.
Well, is there anything to add to our discussion on the onshore wind policy? Or any of the other documents we have been discussing? I think if not, we could move on to item 4 on the agenda. I'm content that I have what I need. Ms. Haywood, have you any comments or questions? No. So if the parties are content, we'll move on to agenda item 4, which is local plan policy. We have the Highland-wide Local Development Plan 2012, and we also have the Inner Moray Firth Local Development Plan 2015, and we also have the Highland Council Onshore Wind Supplementary Guidance 2016. We have already had your substantial written submissions on compliance or otherwise, depending on your position in your written statements. What I'm keen to explore is whether or not there's any difference in emphasis between the LDP and National Planning Framework 4 in terms of the weight given to the climate and nature crises. I know it's far more explicitly set out in NPF4, given that it's a very recent document, but is there actually any real difference in emphasis between the LDP and National Planning Framework 4? The Council appears to take the view that National Planning Framework 4 is complementary to the LDP, and that the approach of the Council is and has long been consistent with national priorities relating to climate and nature change. If we could start with Mr. Bell and with your views on any different view on the emphasis between the existing LDP and NPF4.
Thank you. I think the starting point would be that the LDP was adopted in 2012, so inevitably it has to have been based upon an NPPG or perhaps SPP 2010 way back then. It's silent on net zero, and when we look at a number of the policies, I think there are some clear incompatibilities with NPF4. I'm happy just to go into briefly just explain what I mean by that. So in terms of policy 67, to take that as an example, I note that in terms of the SLA, the Council doesn't rely on policy 57, and that may be because policy 57 is inconsistent with the current SPP of 2014. And so it seems the Council is using policy 67 to ground its reason for objection in relation to the SLA. Now, the big problem I see with that is that, firstly, in terms of policy 67, whilst it refers to a balance of considerations insofar as benefits are taken into account, there's no mention of the weight to be afforded to the contribution to targets, and that is open to a decision maker's discretion, whereas that, as we discussed earlier, is no longer an option with policy 11 or indeed policy 1 of NPF4. Secondly, it requires tourism matters to be taken into account, and notwithstanding the practice that it may not be, as Mr. Finlay said, it's still an element of the policy. Thirdly, the test of significantly detrimental overall is not one that is found in NPF4. Fourthly, in terms of the matter of local landscape designations. The problem the council has, I think, is that in applying policy 67 to draw a conclusion in relation to the acceptability or otherwise of the effects on the SLA, it is simply not following the test that we now have in policy 4. So, in fact, using policy 67 as a proxy for policy 57 doesn't help because of the conflicts that are clear now with policy 57. But I think the final point I would say is that the wording is important because, as I set out in my hearing statement at paragraph 4.1.12, the changes that have taken place to section 24 of the 1997 Act state that in the event of any incompatibility between a provision of the NPF and an LDP, whichever of them is the later in date is to prevail. So it's not so much a matter of aligning or an inconsistency, it's if there's an incompatibility. And I would say that the approach in policy 67 in trying to apply it is incompatible with the approach we now have in NPF4. I think, to be fair to the council, I think Highland has been one of the progressive councils with a pretty good policy 67 of its time, but it's clear now that the policy approach is different and NPF4 should prevail for the reasons that I've set out.
Okay. Thank you, Mr. Bell. Mr. Trinick, did you have any comments? No?
No, thank you, ma'am.
No. Mr. Heinsohn, could you comment on the same question? Thank you.
Yes, of course. I don't think policy 67 is as inconsistent as Mr. Bell has set out. I fully accept it does not set out that significant weight needs to be applied to the climate emergency. It does not set out that a nature crisis, and it does not set out the weight to be attributed to renewable energy generation targets, but it does have it as a consideration. And I think largely, notwithstanding tourism, the considerations set out in policy 67 are compatible with those considerations set out in National Planning Framework 4, and they're also compatible and were compatible with the considerations set out in SPP as well. However, considering policy 57, yes, there is an inconsistency with National Planning Framework 4, and that inconsistency is that the test that is now there for special landscape areas, and it is now a test that wasn't there in SPP. There was effectively a test in policy 57, but it wasn't so explicit, and it didn't set the high bar that has now been set by National Planning Framework 4. Over in the council's reason for objection, as consistent with other appeals that have been undertaken on Section 36 and Town and County Planning cases in recent years, it has been agreed between parties previously that policy 67 would be the primary policy for determination, and all other policies are effectively subservient to that in many respects for this type of development. And I would suggest that that may still be the case. So I accept that there are some inconsistencies, but I wouldn't go as far as to say that it makes policy 67 completely incompatible with NPF4. I would say that there is still some consistency between the two in terms of the considerations, but is predominantly the weight to be attributed to the climate and nature crisis, and the specific reference to the weight to the contribution of meeting renewable energy targets, and of course greenhouse gas emissions that aren't specifically set out. And sorry, just briefly on policy 57, not relevant to this one. It's previously been accepted that other inquiries and by other reporters and ministers that policy 57 is irrelevant in relation to wildland areas as well, and the consideration of that, but it's not relevant in relation to this case.
Okay.
Can I just add,
Yes.
add to that? I think it's important, the starting point is important, that NPF4 will only form part of the development plan. The LDP, as it now is, or may be amended to be, will also form another part of it. So, well, and to pick up your words at the beginning, they're unlikely to be expressed in the same language. But the question is, can they be read compatibly one with the other? And our submission is yes, there, as Mr. Heinsohn's clearly accepted, there's no reference to particular weight in policy 67. But what policy 67 does have is effectively a tilted balance in favour of renewable development, because in the third paragraph, if they're properly sited, located, and designed, they will not be significantly detrimental overall. So it's not a straightforward balancing test. For Highland Council to find something contrary to policy 67, it has to be significantly detrimental overall. So our submission that there's no distinct incompatibility in the overall thrust of policy 67 and NPF4. The two can be read together. There are parts which cannot be read together, and there might be some useful or less than useful legal debate as to the fact that tourism is not mentioned in NPF4 but is in policy 67 is an incompatibility or not. But frankly, we don't need to go there because no one's relying on it in this case. The other part where there is arguably incompatibility is the greater protection now given to SLAs. And I agree with Mr. Bell that the later document prevails in that regard. But that's an element of policy 67. In terms of the overall thrust, it's dated. It was, as no doubt be said, compiled against a different background, very different policy background. But it's general support, and more than just general support for renewable energy developments, in our submission enables it to be read compatibly with NPF4. Albeit that you have to have regard to the newer elements of NPF4 when applying it. So there's no incompatibility, but it does require to be read in context.
Thank you, Mr. Finlay. Any comments from Mr. Bell or Mr. Trinick before we move on from policy 67?
Just whilst they're thinking of their comments, there was one point I forgot to make, which I should have made, was that policy 67, if you like, does contain a test, but NPF4 doesn't. There's no development control test in NPF4. The development control implications. However, I'm not going to be submitting in due course that you apply the test in policy 67. There's an overall approach to be applied, but certainly in our view, and I believe it's Mr. Heinsohn's view, that there's no development control test in NPF4. Some thought will have to be given as to whether this is consistent or inconsistent. See Mr. Bell disagreeing with me strenuously, and no doubt we'll hear why.
I can see Mr. Trinick is waiting to be remuted. And now, for some reason, I appear to have an audio issue. Mr. Trinick, you're having a bad effect. We're incompatible, I suspect. Are you hearing me with an echo, or has that resolved itself?
Is that better now?
Yes.
Can you hear me?
Yes, we can. Thank you.
Mr. Finlay did something and shut me out of the session. I don't know what he did, but not very well. It's possible to write a policy for all seasons. It looks more or less right, whatever the year is. But the fact is that, for the reasons given by Mr. Bell, that this policy is incompatible with policy 11 in NPF4. And I'd just remind everybody of the provisions of section 13 of the 2019 Act, which amended the 1997. In the event, sorry, I don't know what's happening here. Is that better?
Yes.
My machine is doing things without me touching it. In the event of any incompatibility with a provision between a provision of the NPF and a provision of the local development plan, whichever of them is the later in date is to prevail, it's any incompatibility. It's not simply an overall compatibility or a big incompatibility when looking at matters. It's any incompatibility. Policy 67 is incompatible with NPF4. I just draw attention also to the fact that if you stand back and look at policy 67, Mr. Finn is acknowledged it's dated. If you look at the reading justification for the policy, we can see it refers back to the Highland Renewable Energy Strategy 2006, and that was withdrawn years ago, or the planning guidelines of 2006. It even refers to National Planning Framework 2 as a source for the policy. And there comes a time when you can go on saying it looks more or less right, but I'm afraid it's had its day, and it is incompatible with NPF4. Thank you.
It's quite a brief one. I think Mr. Finlay is stating that there is no development management test in NPF4, if I read him correctly. I mean, if that is the case, then I would say, well, what are we to do as decision makers when we apply the latest element of the development plan? I would say that in terms of policy 11, the lead policy, the paragraph we looked at, where it directs decision makers that in considering impacts, significant weight will be placed on the contribution of the proposal. That is, to me, a development management test. One looks at the various topics in 11E, and in considering the impact of it, i.e. in terms of acceptability, one takes into account significant weight on the contribution of the proposal. Thank you.
Thank you, Mr. Bell. If I'm content that I've probably heard enough. As I said, I intend this part of the agenda to be not a specific examination of the policies, and I think we've covered as much as we can. Is there anything else on the relationship between NPF4 and the Highland-wide 2012 LDP before we move on from any of the parties? No, thank you all very much. The next agenda item is item 5, which is helpfully called Any Other Matters, and it really was to offer you an opportunity to raise any other policy matter that you might feel has not been addressed today or not been addressed in written submissions to date. I certainly haven't identified any such matters, but in case one of you has, now is an opportunity to raise it, and hopefully we could address it. Mr. Trinick or Mr. Bell?
No, thank you, ma'am. We're content.
Lovely. And Mr. Finlay and Mr. Heinsohn?
Just very briefly, that the Newry Firth Local Development Plan is under review. It's at proposed plan stage. It will be submitted to examination in the coming weeks
Right.
with the DPA. That contains a number of general policies, and it obviously doesn't hold development plan weight, but it is a consideration. But we don't make submissions on it. It's just really to highlight it to yourselves that it is under review, and it does contain some general policies, and they have been revised to ensure that they're consistent with NPF4.
Okay, thank you. Has that been submitted as a core document? Or
I don't believe it has. No.
Do we need to see it as a core document? I'm not necessarily sure we do. No.
I wouldn't suggest so. No, it was just really to highlight it to you.
Lovely. Thank you very much. Well, that then leads us to item 6, which is our closing remarks. I would like to thank you all for your input and participation today. As usual, it is very much appreciated. And I'd also like to take the opportunity to thank the support staff from DPA, particularly Audrey Devoy, our case officer, and Callum Henderson and Lucy Wakeham from DPA IT, who have helped in organising both the inquiry and hearing sessions and the ongoing administration of the case. Before we formally close the inquiry, is there any other matter or issue that anybody wishes to raise? No? Well, then it remains for me to thank you once again and formally close the inquiry. We look forward to receiving your closing submissions in writing on the agreed dates, and our report will be issued in due course. Thank you all again. Thank you.
Thank you, ma'am.